Good morning, ladies and gentlemen. May I start by saying that thank you very much, Sister, for your inspiration. It's very difficult, to speak after such a powerful presentation, especially on a subject as technical as competition law. But my hope is that, notwithstanding that, we will break it down such that it does make sense, and it's a subject matter that we can relate to. In a nutshell, ladies and gentlemen, South Africa, we are aware, has a long, history of an economy that was a highly concentrated economy, where, the productive instruments of the country were concentrated basically, in a few white hands in our Johannesburg Stock Exchange. So one of the institutions then that were established post-1994 was the Competition Commission, whose objective basically in the main is about making sure that we promote competition, in the economy. We protect SMMEs also against what is called in our legislation abuse of dominance by big companies. We also, of course, because we are a regulator established in terms of legislation, we also enforce the act itself, which is the Competitions Act. So that act also unpacks, ladies and gentlemen, the nature of conduct that is prohibited, that is, what is it that is allowed and what is it that is not allowed in terms of that legislation. That is, what is it that companies may do and what is it that companies actually may not do. So enforcement then is one of the functions of the Competition Commission. That enforcement entails the Commission prosecuting companies that have contravened the Competitions Act. One of the functions that we do is mergers and acquisitions. That is, when a company acquires another in South Africa, they are legally obliged, if they meet the merger threshold, to notify the Competition Commission of their merger. And then in terms of our legislation, we've got powers to approve mergers and to approve them with conditions, and also to prohibit mergers. So that was just by the way of a background, ladies and gentlemen, in terms of who we are and in terms of basically what we do. Why basically are we here? We are here to share with you in terms of how does our work as the Competition Commission relate, or how does it benefit small and medium enterprises. This is just the overview of who we are. So in a nutshell, ladies and gentlemen, when you talk about competition authorities, we're talking about three distinct institutions that are independent of each other. That is the Competition Commission. That is essentially a prosecutor. We're the ones that investigate and prosecute companies that have contravened the Competitions Act. And then we've got two other independent institutions, that is the Competition Tribunal, as well as the Competition Appeal Court. Basically, these two other institutions, they are adjudicative bodies. That is, basically, they review the decisions of the Competition Commission. These are just some of the services, that we provide. Wherein you are uncertain, as a business person, about the conduct that you are about to engage in, you can ask, you can request the Commission to provide you with an advisory opinion, basically. This is just to provide you with guidance in terms of whether that conduct you intend to enter into or to perform is likely to raise competition concerns or not. So we also do advocacy, of course. We look at policies, at legislation, as to whether they may raise competition concerns or not, in terms of their provisions. And we make comments and submissions, to Parliament and government departments. These are now the prohibited practices. In a nutshell, these are called horizontal restrictive practices. So these are issues when I was saying that this is our act actually unpacks in terms of what is allowed and what is not allowed. So when you talk about horizontal restrictive practices, we're talking about a conduct between businesses that are in a horizontal relationship. These are businesses that are competitors basically in the market. So what is it then that our legislation actually prohibits? It prohibits agreements between these companies that are in a horizontal relationship if those agreements have the effect of reducing or lessening competition in that market. And they are categorized into two. First one is rule of reason, prohibition, and the other one is per se prohibitions. Now, what is the difference between the two? Rule of reason prohibited practices, basically it's a practice that companies engage in, but they are allowed justification, that is defenses. You can indicate basically why you have to have that agreement. So, but when it comes to per se prohibited practices, ladies and gentlemen, you are not allowed defenses. That's why they are referred to as per se prohibited practices. Those are your price fixing, your market allocation, and what is called collusive tendering, basically. So those are the prohibited practices that are referred to as per se prohibited practices, meaning therefore that if you engage in any of those three conducts, ladies and gentlemen, then you are not then allowed any justifications. An important point also to allude to is that the Commission prosecutes a firm, not the individual. Just to clarify that point. These are vertical restrictive practices. Basically, these are your agreements between your wholesalers and your retailers. Again, if the effect of those agreements lessen competition in the market, they basically will be viewed as prohibited practices. But again, I mean, this is Section 5.1 of our legislation. If basically that agreement falls under 5.1, you are allowed defenses that you can justify the conduct if there are efficiencies. But even there, we do have a per se prohibited practice referred to as minimum resale price maintenance. Now, minimum resale price maintenance is a price that is normally dictated to by a dealer or a manufacturer to a retailer in terms of the price at which he must sell the product. So in terms of our legislation, I mean the Competition Act, that kind of conduct is a prohibited practices, meaning therefore that it is not allowed. I did indicate that, I mean, in terms of the work that we do, we also do mergers and acquisitions. So one of the considerations that we have to make when we consider a merger is how that merger will actually impact on small, medium enterprises. So that is prescribed basically by the Act itself. So this is one of our public interest provisions in terms of the Competition Act. So one of the measures, for an example, that we considered as the Commission before was a merger between Pick n Pay and a then small company called Fruit and Veg. Now, what transpired there, ladies and gentlemen, was that Pick n Pay actually, apparently they conducted a survey to find out why their fruit and veg section within Pick n Pay, their sales are going down. And then the outcome of that research then informed them that, in fact, what people do, customers do, they buy bulk products from Pick n Pay. However, when they have to buy fruit and veg, they go out of the shop and actually buy from Fruit and Veg, which is apparently cheaper. And so what then they decided to do when they found that actually Fruit and Veg, therefore, is competing with them with regards to fruit and veg products, they took a decision then to acquire, that is to buy Fruit and Veg. So obviously then, ladies and gentlemen, so the intention there was to eliminate fruit and veg capacity to compete with them in the product of fruit and veg. So because then, in terms of the Competition Act, they had to then file that merger with us. Our responsibility when that happens is to evaluate that merger and to investigate whether it will lessen competition in the market post-merger. And in that particular instance, we found that that merger indeed, ladies and gentlemen, would lead to an exit of an effective competitor in the fruit and veg market. And as such, then what we did was to then prohibit that merger, meaning therefore that we did not allow Pick n Pay to buy fruit and veg. Interestingly, the consequence of that is that today, fruit and veg is actually a totally different animal from what it was before. The company was able to expand far more than it was basically when it started. It has acquired a sexy name now called Food Lovers Market. And it has grown phenomenally, throughout the country, and it's also selling not only fruit and veg these days. So, meaning therefore that, that prohibition therefore enabled indeed, fruit and veg to compete in the market, and therefore had the capacity to expand, and grow to the company that it is now. And of course, create more employment, because that expansion needs more resources. So that's why, basically, that's one of the things then that we do as a commission. We also had a big merger, ladies and gentlemen, that happened not so long ago, wherein Walmart, an American big retailer, was buying our Massmart. Massmart is the group that has your macros, your games, and all of these companies. So again, they had to file the merger with us, and there was a lot of fear, in the country in terms of what the implications of this merger are going to be, because Walmart is a huge, big American giant in terms of in the retail space. So one of the concerns that arose then was what is going to happen to the South African suppliers that were supplying Massmart before the merger, the acquisition by Walmart. That was one of the major issues that came up. And then what's going to be their fate post-merger? And there was a big fear that what's likely to happen is that post-merger, Walmart may simply import their products. So to ameliorate that problem, what then our Competition Appeals Court then did was to instruct the merging party to set up a 240 million supplier development fund as a condition to approve that merger. So what was the intention of that fund? That fund was intended to make sure that the South African suppliers to Massmart are able to access that fund and develop their capacity to supply the merged entity, which is Massmart, to the same quality and standards that Massmart is basically used to, such that we eliminate then the need to import products on the part of Walmart. And indeed, ladies and gentlemen, that fund was indeed set up, and it went beyond just providing that assistance to existing suppliers. It also then provided access to those companies and individuals and entrepreneurs that want to enter into that space, which is food and agro processing. There is a very interesting company, a CFA called Letabo Milling in the Free State. It's owned by a very young guy. He's around 30. He is now manufacturing actually milling meal, and is supplying your ShopRite checkers, and is supplying your retailers as well in the Free State and as well as in Gauteng. So like you, he decided that he's tired of working. He wants to be his own boss, and established that company. And also, There is a guy also who was passionate about farming, so he wanted to produce tomatoes. He's a young guy also who grew up in that space. One of the richest land in the country was found in the Limpopo province. So he also then, made use of that fund to actually start his farm, and he is now supplying tomatoes, to retailers, and he's got contracts as well. So this is some of the benefits, that have accrued, from the kind of work that you do as the Competition Commission. So wherein then SMMEs are somehow are going to be negatively affected by a measure, we then attach conditions to protect them such that they don't then go out of business after a measure. And this is just another case that we wanted to share with you. We prosecuted a firm called Sasol Nitro for collusive conduct, and exclusionary conduct. So basically, an exclusionary conduct, sometimes we find that, these companies, big companies, they will actually refuse to supply an SMME because the SMME sometimes it grows to such an extent that it begins to compete, and they simply then squeeze them and not supply them with the product. And then what then happens is that obviously if you don't have access to the product to sell, you cannot then sell the business, then it gets stunted. So these things, they actually then happen. So when that happened, of course, from our side as the Commission, we investigate, and wherein we found that the company indeed has abused its dominance, we prosecute and impose an administrative fine to that company. So in this particular case, Sasol settled with the Commission, and then we attached then a condition to that settlement that they must divest, meaning therefore they must sell some of their subsidiaries. Specifically, their planning facilities located in Durban, Belleville, and Potchefstroom, and Kimberley. So when we order a divestiture, what then that does is that it gives an opportunity for new players to come into that market and actually participate in that market. That then has a consequence of growing, the economy, because you have new players that were not in that space before, who ends up then in that space. And our research also shown that that divestiture in that particular case would have led to significant entry by several smaller players at the blending level of fertilizer. Fertilizer is one of the input costs that are very, very expensive in the agricultural sector. What else are we doing? We are currently doing a market inquiry into the retail space. So we've appointed a panel, and the intention then of this inquiry, ladies and gentlemen, is to find whether in the retail market there are any elements that impede competition in that market. So this is basically the retail grocery sector that we are talking about. What is it that we're going to be looking at? We are going to be looking at what is it the impact, ladies and gentlemen, of the movement of these malls, for an example, into the townships? What is the impact of exclusive lease agreements? And what is the impact also on SMMEs of competition between local businesses and foreign-owned businesses? And also as to whether, there are any regulatory or bylaws that impact negatively, again, on competition. So that market inquiry is still underway. It has not yet concluded. Obviously, market inquiries, they come up with recommendations to be implemented, and not necessarily most of them by the Commission, but they are by the other players. Most importantly, ladies and gentlemen, our Act also provides for this Section 10 exemption. This section specifically indicates, ladies and gentlemen, that we do, as a competition authorities, provide an exemption if the agreement or practice concerned contributes to the promotion of the ability of small businesses or firms controlled or owned by historical disadvantaged persons to become competitive. So, meaning therefore that if you fall into that category and there is an agreement that may auditorily raise competition concerns, our Act provides for an exemption, meaning therefore that you can apply to the competition authorities to be exempted from the provisions of the Act, specifically Chapter 2, meaning therefore that you will not then be prosecuted. An exemption, ladies and gentlemen, very important, is granted. It's not a blank check. It is granted for a certain period of time when it is required. If you still need it further, you can then, you are allowed to reapply for that exemption. But then that is intended such that there is no burden on small businesses in terms of regulation. That's why the Act then is balanced when it comes to them and provides for those exemption provisions. Yeah, that's the long and short of my story, Program Director. If there are any questions, I will gladly take them.